Mr. Kithure, third interested party. I don't believe we joined anyone else. So may I begin by first extending my apologies. Given a time allocation of noon, I was not able to appear at noon. I was still winding up my virtual cause list. The ruling is ready. Let me just bring it up. So this is the ruling on the petitioner's notice of motion application dated 21st August 2024 and the respondent's notice of motion application dated 3rd September 2024. It's a 31-page ruling, so I will not read all of it. I set out the background to the matters from paragraph 1 till paragraph 12. I then cover the relative positions of the parties and the documents filed, just an explanation of what has been filed between paragraphs 13 all the way to paragraph 15. So I'll begin with paragraph 16, which is the first paragraph in issues for determination. Paragraph 16, the parties are in agreement on the issues for determination in this ruling, and they have largely cited the same authorities or authorities articulating the same or similar points of law in support of their relative positions and in opposition of the positions being taken by the parties on the opposite side of the matter. From the applications, the affidavits, and the written submissions, it emerges that the issues for determination are as follows. A, whether the petitioner has demonstrated a prima facie case with a likelihood of success. B, whether the respondent has approached the court with clean hands. C, whether the petition would be rendered nugatory if the conservatory orders sought were denied and were not extended to cover the hearing and determination of the petition. D, whether the respective applicants would suffer an irreversible and irreparable prejudice if their respective application did not succeed. E, where does the public interest lie? And F, costs. So at paragraph 18, I begin the analysis. On the first issue for determination, whether the petition discloses a prima facie case, the applicable legal standard for considering whether a prima facie case has been established in a constitutional petition is whether or not the petition in question raises arguable or triable issues of a nature that calls for a response or rebuttal from the party or parties on the opposite side of the dispute, and which arguable or triable issues have a likelihood of success. Put another way, the arguable or triable issues raised in the petition must be of a nature that, if the party or parties on the opposite side of the dispute failed to respond and rebut the position advanced in the petition in question would have a likelihood of succeeding. I must make clear from the outset that in determining the question of prima facie case at the interlocutory stage, the court must ensure that it does not delve into the relative merits or demerits of the contested legal and factual positions at issue in the petition. The role of the judge is to weigh those contested legal and factual positions to determine if, on the face of it, the petition raises issues that should be canvassed at full hearing of the petition, rather than being dismissed at the preliminary stages, and the petition has a likelihood of success if the matter were to proceed to finality. It is clear that the petition herein raises arguable and triable issues that require hearing and determination post the interlocutory stage. This is not to say that those arguable and triable issues, such as questions of fair hearing, public participation, sub judice, and others, shall necessarily succeed. but they are most certainly of a nature and weight that make them fit and proper for full hearing and determination. This is not to say that the court has, at this stage, formed an opinion on the counter-arguments by the respondent, and to a lesser extent by the third interested party. That the petition is essentially incapable of determination in favor of the petitioner for the reason that the position of governor is a public office position with respect to which there can be no private need or expectation to hold office, a position adopted by the Supreme Court of Kenya in the case of County Assembly's Forum versus Attorney General and 3 others, being Supreme Court Petition number 22 of 2017, KESC 58 KLR. That assertion is one best suited for articulation and determination at the main stage rather than at this interlocutory stage. Similarly, the position taken by the respondent and the third interested party that the failure to join the Senate and the County Assembly of Meru is fatal to the petition, a petition which was strenuously opposed by the petitioner and the first interested party in their respective written submissions, is one best left for the petition stage of this matter, for the reason that the modalities and confines of the interlocutory stage do not lend themselves to an adequate articulation and consideration of matters that go to the heart of whether the petition is merited or not, or if the petition is fatally defective or not. To hold otherwise would be to blur, if not completely eliminate, the distinction between the interlocutory and main stages of the hearing and determination of a petition. The second issue for determination is whether the petitioner approached this court with clean hands. The respondent, in advancing this argument, has at paragraph 40 of its written submissions contended that the petitioner misled this court into granting ex parte interim conservatory orders by not disclosing to this court that the ruling by the Honorable Mr. Justice L. Kassan in Meru High Court Constitutional Petition number E013 of 2024 related to a motion of impeachment by the County Assembly dated 17th July 2024 and not the subject motion of impeachment by the County Assembly dated 31st July 2024 upon which the Senate acted. The question of approaching the court with clean hands is a fundamental one. The issuance of interim conservatory orders ex parte is at the discretion of the court, and should it be subsequently shown to the court that the interim conservatory orders issued by the court ex parte were obtained by the applicant through willful misrepresentation, non-disclosure of material facts, or any other similar conduct, then those orders would be at peril of being discharged, set aside, or vacated, with the further consequence that the applicant would also likely not be in a position to obtain those orders at the conclusion of the hearing and determination of the application that was tainted by the applicant's initial bad faith and conduct. The respondent, in support of its proposition that the petitioner approached this court and subsequently obtained interim relief based on unclean hands, cited Caliph Properties Limited versus Babel, Sharma and another, citation given, which was cited with approval in the High Court succession cause of Mwangaza versus Kerubo, succession cause number E016 of 2023, where the High Court restated the age-old principle that equitable reliefs cannot be issued in favor of a party who has approached the court with unclean hands, and that party's application for injunctive orders must necessarily fail on that ground alone. The petitioner indeed relied extensively in her depositions on what she saw as the sub judice conduct of both the County Assembly of Meru as well as the Senate with respect to the ruling and orders of the Honorable Mr. Justice L. Kassan. However, and similarly to the position taken by this court earlier on the question of prima facie case, I find that a determination of the merits or otherwise of this issue is best reserved for the main stage, rather, due to the nature of the contested facts advanced by the petitioner on one hand versus the respondent on the other. Were it a clear-cut case of unclean hands, which this court could identify and determine at the interlocutory stage, then this court would have no hesitation in doing and determining that question, even at the interlocutory stage. In the present case, the allegation being articulated by the respondent is far more nuanced than the stark instances that were demonstrated in the cases cited by the respondent, and as such, that limb is best reserved for the main stage. Pardon me. All 5 parties before this court in this matter have submitted extensively on the question of whether the petition would be rendered nugatory if the conservatory orders sought were denied and are not extended to cover the hearing and determination of the petition, the third issue for determination in this ruling. The petitioner, the first interested party, and the second interested party have taken the position that without interim conservatory orders in place at the moment, sorry, let me take that again. The petitioner, the first interested party, and the second interested party have taken the position that without the interim conservatory orders in place at the moment being confirmed and extended to the full hearing and determination of the petition, then the petition would be reduced to an academic exercise. Paragraph 11 of the petitioner's written submissions dated 4th September 2024 succinctly articulates the position of the petitioner and the first and second interested parties on this question. It reads as follows. Paragraph 11 of those written submissions. It is our humble submission that the petition should be heard without disrupting the status quo, as failure to grant conservatory orders would render the petition a mere academic exercise of no effect. Indeed, disallowing the application would have the indirect effect of denying the prayers in the petition, given the irreversible nature of the series of political actions that would follow. We invite the court to take judicial notice of the operations of any government where a change of the governor or president comes with far-reaching ramifications that would not be desired in the pendency of the petition to be determined. Close of quotes. The second interested party added its voice to this question in support of the confirmation of the conservatory orders in force by stating at paragraph 27 of its written submissions dated 2nd October 2024 that, paragraph 27, the conservatory orders sought are to maintain the status quo until the issues of violation of the petitioner's constitutional rights are heard and determined to finality. Your Lordship, the process of the impeaching the petitioner ought to be interrogated in order for this honorable court to reach a fair and just determination in the circumstances. Unless the conservatory's orders sought are issued, the petition herein shall be rendered otiose. Unsurprisingly, the respondent and the third interested party are of a diametrically opposite view, but for different reasons. I'm just increasing the font. Perhaps I'm growing old. I can barely read. So where was I? Unsurprisingly, the respondent and the third interested party are of a diametrically opposite view, but for different reasons. The third interested party, at paragraphs 12 and 13 of his written submissions dated 30th September 2024, states that in principle, the third respondent was not opposed per se to the grant of the interim orders ex parte, as was done by this court on 21st August 2024, but the third interested party wondered why they subsisted for more than 14 days, contrary to the provisions of Order 40, Rule 4, Sub-Rule 2 of the Civil Procedure Rules. Paragraphs 12 and 13 of the third interested parties' written submissions read as follows. Your Lordship, a conservatory order in the nature of an injunction is a judicial remedy sought or issued by a court to preserve a subject matter until the suit/petition is heard and determined. It is, in other words, an order of status quo so that the substratum of the suit/petition is preserved, or so that the same is not rendered an academic exercise. Whereas we have no problem with the jurisdiction of the court and the power to issue such orders, we have a challenge in appreciating why the court would issue an order for more than 14 days. Paragraph 13 then continues, Order 40, Rule 4, Sub-Rule 2 states, an ex parte injunction may be granted only once for not more than 14 days and shall not be extended thereafter except once by consent of the parties or by the order of the court for a period not exceeding 14 days. Close of quotes. While constitutional petitions are undoubtedly civil in nature, the civil procedure rules cannot be solely and directly be applied to petitions such as the present one in all instances. The civil procedure rules, and in this instance, Order 40, Rule 4, Sub-Rule 2, must be read together with the Constitution of Kenya, Protection of Rights and Fundamental Freedoms Practice and Procedure Rules 2013, commonly referred to as the Mutunga Rules, and the latter, being specific to this arena, should take primacy. Rule 23 of the Mutunga Rules, and whose marginal note is conservatory or interim orders, does not make any mention of a time limitation on the pendency of interim orders issued ex parte, nor is there any mention of any other requirement such as the consent of the parties, either in that rule or elsewhere in the rules. The Supreme Court has also on several occasions, such as in Gatirao Peter Muñoz versus Dixon Mwenda Kithinji 2014 EKLR, made clear that there is a significant distinction between interlocutory injunctions in private law on one hand and conservatory orders in public law on the other. Therefore, the principles and procedures for interlocutory injunctions in private law cannot be seamlessly applied to conservatory orders in public law. The respondent, on its part, has taken a different route, albeit to the same destination. The respondent, at paragraphs 29 and 30 of its written submissions, argues that the petition herein cannot be rendered nugatory on account of a failure to confirm and extend the interim orders in place, since the High Court has the requisite power to undo any actions that would have taken place subsequent to a refusal to confirm and extend the interim conservatory orders in place. In determining this limb, it must be said that each petition is unique and must be considered based on the specific facts, allegations, and circumstances at issue in that particular case. The failure to grant or confirm and extend interim conservatory orders may render one petition concerning impeachment likely nugatory, but not another, based on the unique facts, allegations, and circumstances of each. A uniform, robotic, or formulistic approach to the question of a petition potentially being rendered nugatory does not take into account differential backgrounds and scenarios. In the present case, the petitioner has satisfied this court that the petition would likely be rendered nugatory and academic if the interim orders already in place were not confirmed and extended to the full hearing and determination of the petition herein. If the interim orders in force were not confirmed and extended as prayed by the petitioner, there would be a succession in the office of the governor of the county, and with it, the likelihood of changes in the staffing of the executive committee and other key offices, a change in the policy and direction of the county, among others. Those changes would not be easy to undo, would not be as easy to undo as the respondent has suggested, even for the High Court, and arguably, they may even be beyond the capability of this court to realistically and meaningfully undo. Were those actions to occur, then a large swathe of the grievances that brought the petitioner to court would perhaps be determined by the actions and decisions taken outside of the court process. To this court's mind, the alternative of preserving the substratum of the petition for the few more months that it would take to hear and determine the petition and arrive at a final determination of the dispute before the court, is more prudent and just avenue to take. The fourth question, whether the respective applicants would suffer an irreversible and irreparable prejudice if their respective application did not succeed, is one which is somewhat related to the nugatory question and is being determined separately, as it was extensively canvassed as such by the respondent. Further, whether it is an applicable limb limb within the grant of conservatory orders is not necessarily the question, since the respondent has submitted on this point extensively. It is clear to my mind that the respondent and also the Senate have no real or significant prejudice that they would suffer if the interim orders were confirmed and extended pending the hearing and determination of the petition. The petitioner, on the other hand, would stand to suffer potentially irreversible and irreparable harm and prejudice if the orders sought were not granted, confirmed, and extended. During the highlighting of written submissions in this matter, counsel for the respondent and counsel for the third interested party both submitted at length that any prejudice that would potentially be suffered by the petitioner could be adequately compensated by way of money damages. However, while that would apply to lost remuneration, money damages cannot compensate for other harm and prejudice that would potentially arise from being removed from office and thereafter being reinstated if the petition were to succeed. Once more, I take the position that it would be more prudent and just to avoid the question of potentially irreversible and irreparable harm and prejudice by confirming and extending the interim orders in force for the few more months that it would take the High Court, as the first court seized with the questions raised in the petition and thus the trial court, to hear and determine the dispute herein substantively. The next issue for determination is where does the public interest lie? The parties have taken strong positions on the same, particularly the respondent. The respondent has canvassed the question of whether the public interest tilts in favor of the confirmation and extension of the order sought or their lifting at paragraphs 32 to 37 of its written submissions. The respondent submits that the public interest militates against the confirmation and extension of the interim orders in force, as the confirmation and extension of the same would amount to a stay of the implementation of the resolution passed by the Senate, removing the petitioner from office by way of impeachment. The respondent has cited the High Court's decision concerning the impeachment of the Deputy Governor of Kisii County, which was Nyamira High Court Constitutional Petition number 4 of 2024. The High Court, in that matter, discharged the conservatory orders that were in force, via a ruling dated and delivered on 13th June 2024. The court observed, and I quote, "The question which arises if this court can issue orders whose effect will be to stay the decision by the Senate to impeach the ninth respondent pending the hearing and determination of the petition. My finding is that since the Senate has already made a resolution, the court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with another organ/arm of government in the exercise of its mandate." Close quotes. Article 165, Clause 6 and Clause 7 set out the supervisory jurisdiction of the High Court in the following terms. I quote Article 165, Clause 6 and 7 as follows. Clause 6, the High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function, but not over a superior court. Clause 7. For the purposes of Clause 6, the High Court may call for the record of any proceedings before any subordinate court or person, body, or authority referred to in Clause 6, and may make any order or give any direction it considers appropriate to ensure the fair administration of justice. Close quotes, emphasis is mine. Impeachment and removal proceedings by the Senate are undoubtedly quasi-judicial in nature. Given that the Senate is not a superior court, a plain reading of Article 165, Clause 6 leads to the inescapable conclusion that the Senate, while exercising a quasi-judicial function, fits into the persons, bodies, or authorities subject to the constitutionally established supervisory jurisdiction of the High Court. Had the framers of the Constitution intended otherwise, nothing would have been simpler than to add the phrase, or a House of Parliament, to the exclusion contained in Clause 6. Furthermore, Article 165, Clause 7 empowers the High Court, in exercise of its supervisory jurisdiction, to make any order or to give any direction as it considers appropriate towards ensuring the fair administration of justice, including staying a resolution of the Senate. The Senate is not insulated from that provision of our apex law by any article or clause of the Constitution. The doctrine of separation of powers and the principle of independence of branches of government should not be extended to run contrary to the plain reading of the Constitution. We should not lose sight of the fact that the Constitution of Kenya 2010 was the culmination of a decades-long effort by the people of Kenya to promulgate a new constitution that would be better able to check against excesses and violations of their fundamental rights and freedoms. The supervisory power of the High Court in that regard, and even over Parliament, is a critical aspect of those checks and balances and the protections built into our supreme law. This is not to say that the supervisory jurisdiction of the High Court over Parliament should not be exercised without restraint and introspection. Simply put, the mere fact that the High Court is empowered to and can supervise Parliament when one or both of the august houses performs a judicial or quasi-judicial function does not mean that it should exercise that jurisdiction in every instance and or issue interlocutory conservatory orders whose effect would be to stay the action or decision of Parliament pending the hearing and determination of the petition before the court. What should guide the High Court is whether the public interest favors the grant or refusal to grant the order sought. Both the respondent and the third interested party have once more relied on the Kisii Deputy Governor case to advance their proposition that the public interest lies in this court lifting the conservatory orders in force, just as our counterpart in Nyamira did. Paragraphs 79 and 80 of that ruling extensively considered the question of the public interest in the petition that was before that court. While the respondent and the third interested party sought to paraphrase those two paragraphs, they did not do that analysis justice, and thus I quote those two paragraphs verbatim. Paragraph 79 of that ruling. Turning to the third parameter for the granting of conservatory orders, which requires the court to consider public interest before granting a conservatory order, I find that the public interest in this matter tilts against the granting of the conservatory orders. I say so because it is the electorate or the people of Kisii County, through the duly elected, representatives both at County Assembly and the Senate, that considered the impeachment motion in accordance with the law and arrived at the majority decision to impeach the third respondent. the ninth respondent, sorry. As I have already stated in this ruling, the decision of the Senate can only be challenged during the substantive hearing of the petition and not through the granting of conservatory orders. I further find that since the office of a deputy governor is a public office that does not belong to a specific individual, it follows that once the officer is impeached, he has to give room to the next office holder unless and until such an impeachment is overturned or nullified by an order of the court. Paragraph 80 then continues, I find that in the circumstances of this case, the rights/interests of the people of Kisii County to be represented and served by a duly appointed deputy governor following the ninth respondent's impeachment far outweigh any prejudice, if any, that the applicant herein will suffer if the orders sought in the application were not granted. I close the quotes, emphasis is mine. The High Court in that matter took the position that the moment the Senate passes a resolution impeaching an office holder, that office immediately falls vacant, thus setting the stage for the filling of that vacancy within the applicable timelines. I note that the High Court sitting in Nyamira was clear that it arrived on its findings based on the particular circumstances of the case before it, as expressly stated in the paragraphs of the ruling that are quoted verbatim above. This court takes the position, as explained earlier above, that the High Court, in exercise of its supervisory jurisdiction over a quasi-judicial function of the Senate, can certainly stay an impeachment resolution of the Senate and restore the status quo ante that obtained before the passing of that impeachment resolution, pending the hearing and determination of the petition. The question, though, is, would that be in the public interest? To begin to answer that question, this court must consider the nature of conservatory orders and thereafter proceed to situate them within the question of where the public interest lies. All five parties in this matter have relied on or alluded to the Supreme Court's decision on the nature of conservatory orders in the ruling dated and delivered on 2nd April 2024 in the seminal case of Gatirau Peter Munya versus Dixon Wenda Kithinji and two others. At paragraph 87 of the said ruling, the Supreme Court stated, and I quote, conservatory orders bear a more decided public law connotation, for these are orders to facilitate ordered functioning within public agencies, as well as to uphold the adjudicative authority of the court in the public interest. Conservatory orders, therefore, are not, unlike interlocutory injunctions, linked to such private party issues as the prospects of irreversible harm occurring during the pendency of the case, or a high probability of success in the applicant's case for orders of stay. Conservatory orders, consequently, should be granted on the inherent merits of a case, having in mind the public interest, the constitutional values, the proportionate magnitude, and the priority levels attributable to relevant causes. I close the quotes. Following on from this examination of the nature of conservatory orders, the Supreme Court in that ruling proceeded to issue conservatory orders pending the hearing and determination of the gubernatorial appeal pending before it. The public interest depends on the circumstances of each case. What may be in the public interest in one matter may not be in the public interest in another matter on the same subject area due to the differences in the circumstances of each matter. The court, in determining where the public interest lies regarding conservatory orders in a case before it, can examine any number of factors or considerations, including A, what impact would the grant or refusal to grant the conservatory orders have on the public? B, how long would it take to hear and determine the petition? That is, how long would the conservatory orders likely last? C, would the grant or refusal to grant the conservatory orders sought foster constitutional principles and values? And D, are there any unique or special circumstances at issue in the matter which are undisputed, which would tilt the public interest in one way or the other? To my mind, the public interest as it applies to the people of Meru County and the wider people of Kenya would be best served by the confirmation and extension of the interim conservatory orders in place, pending the expedited hearing and determination of the petition. The refusal to confirm and extend those orders would result in a gubernatorial succession in Meru County, which in the event that the petition were to succeed in a few months' time, would have to be undone by this court and or other courts at great public cost, if at all it could be undone. That eventuality, if it were to occur, would not resonate with the Supreme Court's binding guidance in the Peter Munya ruling on the aspects of proportionate magnitude and the priority of matters. It should also be considered that in these times of austerity, prudent use of scarce resources, which is also a constitutional imperative, is all the more relevant and a greater consideration in terms of the public interest. The gubernatorial succession in the county, which would result from the petitioner's application not succeeding, would trigger events and changes that would be funded from the public purse. It is prudent to hold off on the same for a very short time and then have them either occur or not to occur based on a judgment rather than a ruling. Secondly, the public interest as it applies to a deputy office holder in the executive branch at either level of government may not be the same as it applies to the chief executive officer. The chief executive officer is the principal person tasked with conceptualizing a vision, strategies, and the consequent policies that would spur that particular unit of government towards greater heights. While certainly the deputy chief executive officer has significant constitutional and statutory powers and gravitas, they are not akin to those vested in the chief executive officer. The former receives instructions and directions from the latter, and consequently, the public interest in implications of succession in the principal office are more consequential than those in the office of the deputy. Thirdly, the people of Meru County elected a governor, and it is in their overriding interest that their elected representatives at the county assembly level, as well as their national representatives in the form of the Senate, only extinguish the people's choice and expression of their sovereign will for constitutionally permissible grounds that are proven to the required standard after a constitutionally compliant process. This public interest element necessarily requires that the adjudicative authority of the High Court be maintained and be seen to be maintained for the short period of time it would take to hear and determine the petition on its merits. Lastly, on the public interest, none of the parties opposed to the continuation of the orders in force have elucidated any unique or special circumstances at issue in the matter which are undisputed and which would tilt the public interest against the petitioner's prayers. Consequently, it is my finding that the public interest favors the continuation of the subsistence of the interim conservatory orders in force pending the hearing and determination of the petition. Turning now to costs, noting the foregoing and the circumstances of this matter, it is fit, just, and proper that each party bears its own costs. Excuse me. Having analyzed the issues for determination, it is my overall finding that the petitioner applicant has met the requisite legal threshold for the grant of conservatory orders and for them to be confirmed and extended to the full hearing and determination of the petition herein, and thus the respondent has failed to satisfy the court to the contrary. For the avoidance of doubt, and for the benefit of the members of the public who have been following this matter with great interest, the court is not saying that the petition will succeed or that it will fail. Rather, the court has found that in terms of the applicable law and legal considerations, it is fit, just, and proper for the interim conservatory orders in force to continue to apply for a little while longer. Paragraph 66. Ordinarily, a ruling such as this would end there, but there is a critical aspect that this court must plainly state. This court has repeatedly, in the foregoing paragraphs, and with respect to various limbs of the applicable legal criteria, expressed its position that it would be prudent and just to confirm and extend the orders in force for the few more months that it would take to hear and determine the petition. The court cannot, therefore, rest its pen before expressing clearly what that short period of time would be and what the obligations on the parties, and in particular the petitioner, would be. Paragraph 67. It is regrettably the case that in some instances, petitioners who are successful at the interlocutory stage in terms of receiving a grant of conservatory orders pending the hearing and determination of the petition, thereafter seek to delay the progression of the petition. They do so, of course, to benefit for as long as possible from those conservatory orders without reaching the point at which those conservatory orders may cease to exist, that is, the judgment date. This phenomenon has been the subject of much discussion in judgments in this and other jurisdictions, at colloquia, at trainings, in scholarly articles, and in both traditional and new media. What is clear is that there needs to be a balance of the competing positions and interests, so that in issuing conservatory orders pending hearing and determination of the petition, there is no scope for abuse of the court process or deliberate delay of the progression of the matter. To my mind, a court has two approaches that it can take in addressing this concern. The first is to issue a schedule with comprehensive timelines running all the way to the date of highlighting of written submissions. The orders confirmed and extended would then have to be confirmed and extended to a definite date rather than being open-ended, and the court would then extend them further to the judgment date it would issue at the conclusion of highlighting of written submissions. Such an approach would mean that the schedule and timelines would either be issued within the attended ruling or in separate directions that would derive their compulsive force from the ruling. The second approach would be to confirm and extend the conservatory orders for a specific period of time. The court would, in arriving at the period of time for which those orders should subsist, calculate the time needed for the various filings and milestones, culminating in the delivery of the judgment, with the judgment having the ability to bring those orders to an end if the petition was unsuccessful, even if the time for the same was yet to lapse due to the court having been guided by an abundance of caution. Paragraph 71. At this juncture, and before I articulate which route shall be applied in the present case, it is important for this judge to state that nothing in the conduct of the petitioner informed the proposed adoption of the above. The petitioner has been diligent in meeting all applicable timelines since filing of this matter on 21st of August 2024 to date, as have the respondent and the three interested parties. The petition and the petitioner's notice of motion application dated 21st August 2024 were filed on 21st August 2024. That means today's ruling is being delivered exactly 119 days from the date of filing of the initial application in this matter. Let me read that again. That means that today's ruling is being delivered exactly 119 days from the date of filing of the initial application in this matter. To arrive at this point, and having determined 4 other applications within the same 119 days from inception, could only have been possible due to the exemplary cooperation and diligence of the parties herein and their able counsel. Accordingly, each of the counsel in this matter is commended by this court for their diligence and professionalism in that regard. Turning now to which path the court will take, this court is minded to apply the second approach, and thus I shall in this ruling confirm and extend the interim orders for a defined period of time, which I shall formally pronounce under the disposition heading of this ruling. Disposition, paragraph 73. Consequently, and for the foregoing reasons, this court issues the following orders. A. The petitioner applicant's notice of motion application dated 21st August 2024 is hereby allowed in the specific terms to be set out at paragraph C below. B. The respondent's notice of motion application dated 3rd September 2024 is dismissed. C. The ex parte conservatory orders issued by this court on 21st August 2024 are confirmed and extended for a period of 120 days from the date hereof, and in that time, the petitioner shall continue to serve as the governor of Meru County, with a proviso that the judgment in this matter may be rendered before the lapse of those 120 days from the date hereof. Due to the import of that paragraph, let me read it again. The ex parte conservatory orders issued by this court on 21st August 2024 are confirmed and extended for a period of 120 days from the date hereof, and in that time the petitioner shall continue to serve as the governor of Meru County, with the proviso that the judgment in this matter may be rendered before the lapse of those 120 days from the date hereof. D. Each party to bear its own costs for the 2 applications. And finally, E. Directions on the hearing and determination of the petition within the period set out in C above shall be issued by this court immediately after the delivery of this ruling. Dated, signed, and delivered in open court on this 18th day of December 2024. I will then add the counsel who appeared in the matter.
Thank you very much, Your Lordship, for the lengthy but well thought out ruling, which we consider to be outside the box. We want to go on record as committing to comply with very stringent directions issued by the court, because we are committed to a timely and expeditious disposal of this matter. That is the reason why we moved the court on a certificate of validity. We undertake to comply. Secondly, Your Lordship,
Yes.
Subsequent to the filing of this petition, there were proceedings that took place at the Senate which have a bearing on this case. Unfortunately, the same came after we had closed